Please. This is the review. Malas, this is the review, Malas. I have my first is of Lordship's order. We are aggrieved by paragraphs 214 to 217, which is retrospective application of the TET qualification, Malas, for teachers.
You're for All India Primary Teachers Federation?
Malas, state of UP, Malas.
No, which is the first matter?
State of UP is the first matter.
State of UP.
But there are a number of states mirrors also.
You're agreed
were
by
not
the
party-
retrospective or the prospective application of the
Well, it's
provisions?
retrospective application of TET qualification for people who had already been selected as teachers.
So what, how do you construe the second proviso 223?
Well, it's this.
Just
Not like this, madam. You will have to decide amongst yourselves who will address us first, who will be the lead counsel, and thereafter if somebody wants to supplement, we will definitely hear them. But not like this that one statement from here, one state from there.
the solicitor will start.
You will have to decide amongst yourselves who will address us.
Let the solicitor start first.
Yes.
Malas,
Let the solicitor start. Very well.
may I
Let the
read
solicitor.
Section 23. Malas, may I read?
Sir, I am.
Take this mic.
Of Andaman and Nicobar. Lord, I am requesting for our review petition tagged with the main petition.
Huh?
Our review petition may be tagged with the main petition.
Wait. Let us hear the others.
Malas, may I?
Yes, please.
May I start from here? I think.
Yes, of course. You are state of Uttar Pradesh.
Yes. State of Uttar Pradesh. Malas.
ये क्या चेंज हो गया ऑर्डर?
My lords, I am appearing for the MP Association. Whenever your lordships permit, I'll.
Malas,
Right.
may I start?
Yes.
Malas, may I place 23 for Lordship's pleasure? Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Malas will mark that any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment. So that is one. That does not include TET, Malas.
That does not include TET.
TET. Malas, that comes later, Malas. That's how we would construe it, Malas, at least from my submission. 2, where a state does not have adequate institutions offering courses or training in teacher education or teaching, teachers possessing minimum qualification as laid down in subsection 1 are not available in sufficient numbers, the central government, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years. So this is about academic qualifications. Training qualification, provided that a teacher who at the commencement of this act, so this is a proviso, does not possess minimum qualifications laid down and shall secure such minimum qualification within a period of 5 years. Then, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down in subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Free Education Amendment Act 2017. Malas, that's what it says. But Malas will then come to what lordships have observed in the.
What do you make of this? Or in position as on 31st March 2015.
Malas will please come to. Malas, I'll just take Malas through that. Malas will please come to the order, Malas. I'm sorry. Will bear with me, Malas. Impugned order. And what we are aggrieved by. Well, it has page 214. May I please, para 214 of the impugned, page 108.
Just tell us the para number.
para 214.
214. Yes.
For the detailed discussions above and resting on the same, we hold that the provisions of the RTE Act have to be complied with by all schools as defined in 2N of the RTE, or 2N of the RTE, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided and subject to the answers to the question formulated under Section 7. Logically, it would follow that in-service teachers, irrespective of their length of service, would also be required to qualify TET to continue in service. Others will thereafter, others will bear with me. However, we are mindful of the ground realities as well as the practical challenges. There are in-service teachers who were recruited, Lordship has obviously recognized that, much prior to the advent of RTE Act, and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by have not shown in life to dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, though we are alive to the settled legal position that operation of statute can never be seen as an evil. Bearing in mind their predicament, we invoke our Article 142 of the Constitution and direct that those teachers who have less than 5 years of service left may continue in service till they attain the age of superannuation without qualifying the TET. However, we make it clear that if any such teacher having less than aspires for promotion, he will not be considered eligible without having qualified TET. Then, Malas, this is insofar as in-service teachers recruited prior to the enactment of the RTE Act and having more than 5 years to retire on superannuation are concerned, they shall be under an obligation to qualify the TET within 2 years from the date in order to continue in service. In any of such teachers fail to qualify the TET within the time we have allowed, they shall have to quit service. Malas will see the section. Lordships have said the proviso. This portion, especially which Lordships have indicated, they shall be on an obligation to qualify TET within 2 years. If any such teachers fail to qualify the TET within that time we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever terminal benefits they are entitled to. We add a rider to that, qualify for terminal benefits. Such teachers might have put in qualifying period, obviously with qualifying service. If any teacher has not put in qualifying service, well, it's this compulsory retirement and will not be entitled to continue in service. Well, it's my submission. That is not reflected directly what Lordship has said. Well, I can take my law through the notifications and what has happened, but this does not reflect in the section as well. What my
What is
lord,
the object of the act, Mr. Solicitor?
the object of the act is right to education, so that
Right to
obviously
education.
everybody gets
For children,
for
for children,
no
to
doubt.
exist for the children.
Yes, Malad. But Lordships
Don't
have
be so self-centered
not at all, Malad.
that only I will be getting orders from the court protecting my service. There should be security,
There are
but we will not think about the children.
no, not at all, Malad. May I?
You have to give some meaning to the second proviso.
May I?
Please give some meaning to the second
Well,
proviso.
Malad, it has to be
The
read as
scheme of the act, the statutory scheme was this.
Yes.
Initially, within 5 years, you have to. The legislature was alive to the challenge that there may not be institutions. That is why relaxation was also there,
yes.
right? You did not comply.
Malad, 2-1.
No, you did not qualify the examination.
Yes.
Again, in 2017,
Yes.
the second proviso comes in. Why? What is the purpose of the second proviso?
Malad, what Lordships have also noted at 215 is also extremely important. Malad, the entire basis of what Lordships, my
Trying to
understanding.
balance the interests of all the
Malad,
teachers.
No, my lords have also considered, and I'm saying this, Lordship
2017
genuinely also considered.
2017 gives 4 years,
Yes.
but it is with retrospective effect from 15. So you get only 2 years time, 2017 to 2019. In 2025, we are giving another 2 years time.
Yes. Well, I'm not denying it, but
So
Lord,
the teachers will not qualify, the teachers will have the right to continue giving the second proviso a complete go by.
Malad's asked submission is this. Malad's will
Mr.
again bear with
Solicitor
me.
and all other learned counsel, please throw some light how you overcome this second provision.
What? 23rd August.
We have kept it for open hearing
Yes.
only for this purpose.
Fellows will come to the 23rd August notification.
So, sir,
Fellows,
it's
this is
para
in
9 and
pursuance.
10.
Fellows will please come to the,
Yeah, Milord.
which
Para
23rd
9
August
is all the
2000.
We'll have to decide one after the other.
I'm sorry, Milord.
Not that solicitor is in the midst of his argument, somebody start.
Malas will please come to the
We'll take his
notification.
seat, we'll call upon the next.
Malas will,
Not like this. Otherwise, there's,
Malas will just bear with me. This was brought into effect by the 20th, put into effect by the 23rd August notification, which is page number.
No, this is in the NCT affidavit.
This is in the NCT affidavit, page number 53.
state of UP.
The
Malas
NCT
will-
Well,
It's part of the NCT affidavit. This was,
in the main.
It's not in your
It's
review
20.
petition, Mr. Solicitor.
I'm sorry,
It's not in your review petition.
it's not, it's quoted. Is it quoted?
No. If it is not there,
इसमें देखिए,
don't expect us to pick it up from anywhere.
it's, I have
Should
it
have annexed it to the review petition,
maybe
or you should have all come with a compilation of
violation. It's page-
the statutory provisions and the notifications,
Notifications, Malas.
so that, we don't have to struggle to find it out.
3-1, Malas.
0.31. No, 0.19.
would I,
Very well. You have made your point that this cannot be given retrospective effect.
And Malas will also see
Could
I-
that it was brought into effect, Malas.
We'll note it.
The NCT notification, page 49 of,
This we can pass.
Malas will, my learned friend.
This cannot be a re-hearing of the entire matter, so let us give chance to every council.
my lord,
Right? Mr. Banerjee's submission, we are recording.
Malas, so, Malas, our submission is, it was brought into effect, Malas, in short,
Very well. This is your point.
Malas, 1, and was brought into effect by that 23/8/2010, which has been interpreted by this honorable court saying that it's prospective in application. The exact, Malas, that is also, I'm just mentioning that. Arvind Kumar Yadav,
Give the citation.
Anand Kumar Yadav. Malas, that citation is 2018-13 Supreme Court cases, 560. Para 27. And para 28, please.
27
And
and
28,
very well.
which, that's the NCT notification which brings into effect this qualification. And that says it's prospective.
would I assist your lordships?
Malas,
Mr.
that-
Jha, Mr.
Yes,
Jha,
sir.
please wait for your turn.
Yes, madam.
Please wait for your turn. You're not
Yes.
here physically, you're joining through the virtual mode.
I'm
You
grateful.
have the
madam.
right of pre-audience.
I'm
When there are
grateful.
senior counsel who are enrolled before you in the bar.
I'm grateful, my lord. I'm grateful.
Yes, Mr. Divedi, you're the
Yes,
senior most?
yes. No,
You're
I
the
don't.
senior most?
Seniority matters, but
No, we'll go by seniority then. We'll go by seniority as per enrollment.
yeah, we want review. Yeah.
Malas,
We'll strictly go by section 23 Advocates Act.
Right, the problem is we don't know our seniority.
You don't know your seniority.
We don't know our
Well, you'll have to figure it out.
We'll just take 2 minutes time. Let me.
Takes me 3 minutes, sir. We will.
Gotcha. 2 minutes.
Malas,
3 minutes.
I'll excuse
So-
myself from.
Very
So
well.
well,
Let
Lordship,
me-
a very short point, or should just note the point. I'll take.
So the
three or four
point
minutes.
obvious.
Just one by one.
Yes, three or
Mr.
four.
Bhattacharya, please wait. Let Mr. Divedi take 2. Dr. Singh will stay. Right.
So kindly have the
Malas-
second proviso, Mullards.
Acha,
Kindly have the second proviso, Mullards.
Mr. R. Divedi.
I am appearing for the state of Madhya Pradesh, Mullards. Just bear in mind one fact, not that prior to the enforcement of this act in 2009 and the issuance of the notification under section 23, one by the academic authority on 23rd August 10, we had our own set of rules, Lord, and an examination also for recruiting the teachers. So everybody has, and the qualifications which are prescribed under 2000 and under section 23(1) are substantially similar as in our rules, Lord, prior to 2009. After 2010 in Madhya Pradesh, everybody has a TET. Question is of my lord extending this to a point of time prior to the emergence of this act itself, my lords. So I am only, my lord, attempting to draw your lordship's attention to the extension of retrospectivity prior to 2000, this emergence of this act, my lord, and the notification of 23rd August. Now, please see the second proviso.
Yes.
Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1. Please mark this expression, as laid down in subsection 1. Now, this notification, therefore, this takes us back to 23.1. And 23.1, the notification has come on 23rd August 2010. So therefore,
Like this.
it is only, my lord, the retrospectivity can be only to the point, my lord, when the qualification was prescribed under 2010. It cannot, my lord, extend to 1998 and 1995, my lord, when the teachers were recruited. So, if after 2010, there is somebody lacking TET or other qualification, I'm assuming that TET is also qualification. That's what your lordships have observed. I'm not for the moment questioning, Lord, as far as I'm concerned. So assuming TET is there,
Well, thank you.
the TET came in 2010. Before that, we were having our own examinations, Lord, and there was no TET.
Well, is my, sorry.
So therefore,
Just tell you what I have noted from your petition, State of Madhya Pradesh.
yes, ma'am.
Education is a state subject. There existed state law prior to the coming to force of the
Yes.
RTE Act. RTE Act does not automatically override the state law. This is one point. Court had no occasion to examine the interplay of RTE Act with state laws. Interpretation of court does not align with the statute and rules thereunder, which never intended to apply TET to in-service teachers. SOR of RTE 2017 highlights that infrastructure was sought to strengthen the training for the untrained teachers. Intention behind including proviso can never be to apply to in-service teachers. Over 70,000
So
teachers.
your lordships have rightly noted the submissions from them, but I am not pressing, I am not saying, my lord, that after 2009, our state act will continue. I'm not saying that. I'm not saying, so,
So,
please.
for those teachers who have been in service for more than 2 decades, 3 decades, we have provided a relaxation for them depending upon their age.
But this,
Those who are 55 plus, they need not.
but
We have
great,
exercised our
with great deference, my lord, second proviso does not, my lord, require, extend, my lord, its application to those recruited earlier.
What do you mean by 31st March 2015, sir?
My lord, that has to be restricted to the notification because it says as
No, no.
provided in subsection 1.
Every teacher notification under 23(1) prescribes the qualifications which every teacher has to possess. Second proviso extends the time period that if you have not acquired the qualification within first 5 years, we are extending it for another 2 years. Otherwise, this proviso does not bear any meaning.
My lord, if it is not extended earlier to this point of time, 23rd August 10, it will be manifestly arbitrary, my lords.
We'll consider.
My lord, kindly just examine, my lord, if today we are required to pass the bar council examination after
No,
30
this
years.
argument was raised, Mr. Divedi. This argument was raised before the bench. We had the occasion to
This
consider.
act does not purport to repeal our state acts and rules retrospectively. my lord.
We'll consider. We are not saying we'll not consider. We'll
Now,
consider.
well, it's my.
Dr. Singh,
my
you are for whom?
I am for this entire batch of 2001, 2002,
No, no,
2003.
in the
Individuals.
individual, what is the name of your client?
301.3. 300 point? 301.30. 301.30.
Can you give the
30th.
name of the party?
Amit Kumar Singh. That is, will you stop a commentary? 301.30. Amit Kumar Singh. I only have 4 dates to give a lordship. Only
That's
4.
very well. Amit Kumar Singh.
Yes. You should keep this compilation on the side. My 4 dates are this fellows. There was, just 4 dates, lordship will note. There were 3rd September 01 regulations.
3rd September?
01. That is well as 25 years ago.
Yes.
In this compilation at page 23 are the extant regulations on that date. I was clearly qualified under them. Please give it to my lords. Page 23. Only 4 dates and 4 documents. Well, I won't take long. And Lordship need not go into the merits of it, just glance at it as to whether this is 2001, September. That table, Malas, don't go into the nitty gritty of it, but they clearly qualified under that. This is my compilation.
You said 3rd September 2000.
One.
This is not there in your compilation? Second, very well, 17 to 24.
Yes. It's the relevant part only I'm showing Malas 22 at 23.
22 at 23.
Number 2.
Yes,
Malas, number 2. Of course, in between now comes on 1st April 2010, the Act, the RTE Act. That date is 1/4/2010.
yes,
On 23rd of August 2010,
yes,
a notification is issued requiring the TET. Right, Malas?
yes,
But it has a significant exemption because they know that there are 50,000 plus teachers like this in the rural areas who don't have this qualification, who have the other one. That is relevant at 31 of this compilation.
30?
Yeah, it starts at 29. Joshua may ignore the rest.
31.
At 31, that exemption is consciously given to protect people like me. Teachers appointed before the date of this notification. Of course, I'm in the hoary past. Even immediately before this is 2010. The following categories of teachers appointed from classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified. Then, Malas, a particular category is A. If appointed on or after, then there's a proviso. We are not concerned with that. The third is that this exemption at page 31 is reaffirmed and reiterated at 34. That's my third point. 29th July 2011, Lordship has reached now. That is 1 year after the RTA Act.
Yes,
Justice Banmohan has got 34. On this date, the relevant part of this is at 34 starting, 35 is the relevant part.
yes,
Teachers, 5A, teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointment may be made in accordance with the NCTE regulations of 2001, which I showed to your lordships. Conscious exemption because they didn't want to penalize people who had done to the best of their ability in the hoary past something, which was then the valid thing. Then, Malas, comes the amendment to the Act as the fourth document or the fourth point. That is at 38. 38. That is the NCTE Act amended 38 at 47 is the amendment of 12 capital A. 12 capital A. This is Malas WEF 16/2012. WEF 16/2012. Lordship, we got 12A. Justice Banmohan has got 12A. At 47, Malas 38 at 47. 38 at 47.
yes.
Now, I am interested in the proviso, but your Lordship may read the whole. Power of the Council to determine minimum standards of education. For the purpose of maintaining standards of education, the Council may by regulations determine the qualification of persons who will be recruited as teachers in any pre-primary, primary, upper primary, secondary, senior so-and-so, intermediate, by whatever name called, run, aided or recognized by central government. Provided, if your Lordship doesn't mind, provided that nothing in this section shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, senior, secondary, intermediate, or the colleges under any rule made by the central government, state government, local authority, other authority, immediately before the commencement of the so-and-so Amendment Act of 2011, solely on the ground of non-fulfillment of such qualification as may be specified, provided further that the minimum qualification referred to, etc. These are conscious statutory or delegated legislation exceptions.
No, read further, provided further.
Yes, provided further that the minimum qualified teacher referred to of the first proviso shall be acquired within the period specified in this Act or under the Right to Free Act, etc. Correct?
So you will have to acquire it.
No, Malas, now, these are people who have been there, Malas, 50 years.
Maybe the statutory provision is that you have to acquire it. See, the problem that is arising over here, Dr. Singhvi, is precisely this. This proviso says that even the teachers who've been appointed prior in date
Yes.
will have to get this
That,
additional
that may
qualification.
not be the right interpretation. May I
No,
explain why?
see, we have
I-
looked at it and my brother has explained it in detail.
So therefore,
We are
I'm trying.
looking at the act from the perspective of the child. We are saying higher education qualifications of the teachers is required because we must get the best teachers.
So, Malas,
See, unless until you get good quality education, how will the child improve?
so my answer is this.
You have to have good quality
I am
teachers.
requesting my lords to interpret it as a very strong alternative interpretation. This one which your lordship asked me to read is a proviso which will apply to those appointed after the act but before the amendment.
No, that is not so.
Before the amendment. No, Malas, because the amendment says so.
We'll
That's the
consider.
contention.
We'll
Malas, please see.
consider.
This is brought by an amendment.
We'll-
It's
we'll
not
consider.
brought by the act.
We'll
Those are-
consider. We'll
But can I
consider.
have
You're obliged.
5 minutes?
Yes.
5 minutes.
Just to add what Dr. Singh said, but after.
Just 5 minutes. Lord, kindly,
Who are you for?
I am for Milord point 57 Jyoti Singh. So Milord, if your lordship had those 4 dates again, without reference to papers.
Jyoti Singh.
Yes. So Milord, the first relevant date is 1/4/2010. That's the commencement of the act, Milord. The act of 2009 came into effect on 1/4/10. So prior to 2010, there was no real problem. On 1/4/2010, my lord, there was no TET requirement. The requirement came, my lord, on 23rd August 2010. And then, my lord, is the last date, which is, I think, 23rd of August 2017, when the second proviso, my lord, was added, which takes us back to being in position in 2015. That's, my lord, the conspectus. That's the conspectus. Now, my lord, if your lordship will be pleased to see section 23 and the notification of August 2010. Just see 23 once again, my lord.
Yes.
Any persons possessing minimum qualification is laid down by an authority authorized by the government by notification shall be eligible for appointment. As so, this is, my lord, prospective. Those who are going to be appointed. Then the lordship sees, my lord, the first proviso. Provided a teacher who at the commencement of this act, commencement of the act is 1/4. The commencement is not August. Whoever, my lord, at the commencement of the act, that is a person, my lord, who's already there. So there are two different, my lord, groups. Under 23(1), those who are going to be appointed henceforth, and this proviso is those who are already, my lord, in place. Those who are, I'm reading, my lord, that way, those who are teachers who are at the commencement of this act, that is, my lord, on 1/4, do not possess minimum qualifications. Under 1 shall acquire. The submission is, my lord, that people like us who were there as on 1/4, we possessed the qualification under 23(1) because there was no August. There was no TET. So to say, my lord, that we will be given a grace is wrong because the issue arose in August. So on first principles, those who were in place by virtue of, my lord, this proviso would only be required to fulfill 23(1), and 23(1) on 1/4/10 did not have TET. That's one part. Now, my lord, your lordship may have a look at the notification of August. My lord, your lordship might have it in Mr. Singhvi's compilation.
Mr. Roti has not looked at second proviso. The whole case is on second proviso, not the
Sec-
first proviso.
Second proviso comes in 17. I'll come to that, my lord. Please bear with me. First point I'm making is this proviso does not apply to me.
First proviso, not on the first.
I'm developing the first, then I will go to the notification, then I'll go. Obviously, my lord, if you just read the second, then obviously if you look at it that way, then everything is gone over. What I'm trying to say is, my lord, I was not requiring any grace as on 1/4/2010. In short, I didn't require a grace. I was very much in place with the requirement of relevant qualifications as on, my lord, 1st April 2010, the first submission, without grace. Now, my lord, see,
1st April 2010,
my lord,
the qualifications had not been prescribed.
correct,
Correct?
correct,
It came into existence
August,
on 23rd August 2010.
right,
So therefore, what the first proviso ordains is this.
huh,
If you are a teacher on 1st April 2010,
yeah,
you are given 5 years time to acquire the qualification. From which date 5 years will count? It cannot count from 1st of April 2010 because the qualifications had not been prescribed.
correct,
It will count from the date the qualification is prescribed, that is 23rd August 2010. You have a window of 5 years. 2015, if you don't qualify,
I understand, lord.
2000,
Yes,
you
yes,
see, that is why it is again made
my lord,
effective with
I-
retrospective
I-
effect.
I submit,
You are given 2 years time,
I
5 plus 2.
am only saying, my lord,
In
that
fact,
the first proviso talks about commencement of the act.
Mr. Roti, my brother has been very benevolent in giving you some extra time. I was telling him, let the statute operate as it is. And we had a long
All
discussion on
right,
this.
so one more argument, one more argument.
He's been very, very benevolent.
Now, one more argument, my lord, which is based on what your lordships gave me in the order. Kindly turn to the order. Let me read the order first, my lord, and then make the submission. Kindly turn to para 168. 168 of your lordship's judgment.
Paragraph 168.
Yes. NCT 168. The argument is this, my lord. In other words, that the requirement of TET is only for those who were appointed post August 2010. In that light, we were exempt in 2010. My lords will remember, we were exempt under 2010. Can I just show that and then read 168? 168 is completely in my favor. May I read 160?
Read it, but just answer one question.
Yeah.
EET requirement gets incorporated on 1st August 2010.
Sorry?
EET requirement gets incorporated.
Yes,
on 1st
absolutely right.
So there can be no recruitment after 1st August 2010.
Without that.
If your submission is accepted, then the second proviso will have no relevance. It should never have been there.
So what I'm trying,
Therefore, Mr. Rothi, you're missing the point. The point is of what is the significance of second
my
proviso?
lord, second proviso does not specifically say that the exemption granted in 2010
It is
is
what-
gone.
Who are in position on 31st March
Of course.
2015, they will have to acquire it.
Mr. Rothi,
So by,
understand, the teachers have to upgrade their skills.
Achha,
They
just-
have the best standards for the
No, I-
teachers.
I-
Examine it from the
I've
student's
seen,
point.
Lord, I've seen,
Let them have the
which,
best
I am
teachers.
seeing which way the wind is blowing. So I won't put it another way. I just want to read 168.
Okay.
This is not in my favor. That's why I'm reading it. Para 168. NCT's notification reinforces this requirement by stating that teachers working in unaided schools or those in position as on 31st March 15, like me, my lord, must qualify TET. Now, next para is important. The language of both the RT and the notification leave no room for ambiguity that even those who were appointed prior to RT, like me, if not qualified, must not be TT against me within the grace. Now look at the next line. Only those appointed prior to so and so in accordance with those applicable rules or covered by specific exemptions. This is in the notification of 2010 are exempt.
Exempted, but thereafter 17 does not grant you
Not-
that exemption.
You know, if you are
This is the difficulty.
you are exempted and then you take what you give
Well,
by the left
yes,
hand, you
yes.
take it away by the right.
Yes,
What happened?
Just add one line.
yes, yes.
You had your fill.
Mr.
You had
Mr.
your
Gupta,
fill.
you were there?
You had your fill in the previous round. How many days we heard you?
May I remind you a lot?
5 days.
He should not be stopped, you know.
No, not a,
No, no, my
but
lord.
Mr. Gupta will hear you because there are other people.
If your lordship is going by seniority, my lord, then Mr. Bikash Bhattacharya should be heard first, then me, then my lord,
then
the
the
rest.
others.
Yes.
Very well, we'll go by seniority.
I will keep myself confined specific to the question of Milord 23 proviso, second proviso.
Second proviso, yes.
May I read it, Milord?
Mr. Bhattacharya, for whom
1931 and 39. And 2325.
Now just give the
19.
first party's name,
Vidhan Kumar Mondol.
Vidhan Mondol. Vidhan Kumar Mondol. Right.
And Shamoli Haldar.
And Shamali Haldar.
0.31 Shamoli Haldar.
Rashmi.
Sonali Chaudhary.
Is-
And
is-
0.3.
Vidhan Kumar Mondol. These are separate review petitions.
Yes, madam. 3.
Shamali and the last one,
Sonali Chaudhary.
Sonali. Very well. Yes, Mr. Bhattacharya,
The Milord, section 23 Milord should be read in its entirety.
right?
Yes. Now, Milord, the first is Milord, the Act desires that there should be a prescribed qualification by competent authority. And then say that any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher. This is the prospective in operation. Now, second is where state does not have any adequate infrastructure, they will be given 5 years time. Then let's second, provided, the first proviso. A teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And then second proviso, provided further, this is important that we are governed by this, that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Education Act. Now, our appointment was, Milord, at a point of time when, Milord, the academic qualification was, Milord, determined by the NCTE. And my Lord will kindly turn to, Milord, the
Regulation.
in the matter of, Milord, Anjuman
Vidhan.
Vidhan. Milord, kindly turn to, Milord, page 155.
What is that? What is that 155?
155 is the NCTE, Milord, regulation, notification,
Dated
dated 23rd of August.
23rd August 2010.
Yes.
Very well. Yes.
Now, Milord, here, my Lord, we'll find, Milord, details are given, then kindly come to, Milord, at page 157.
You just refer to the regulation number
Yes.
because we are looking at this compilation.
Milord, regulation 4 of,
Regulation 4.
yes, of 23rd August 2010 regulation.
Regulation
Notification.
4.
Notifications.
2010 notification.
Teacher appointed before the date of this notification.
Yes,
Is that the marginal note?
yes. Teacher
Yes.
appointed before the date of this
This
notification.
notification. Yes.
The following categories of teachers appointed to class 1 to 8 prior to date of this notification need not acquire the minimum qualifications specified in para 1 above.
Right.
A teacher appointed on or after 3rd of September 2001, that is the date on which NCT determination so-and-so regulation 2001, as amended from time to time, came into force in accordance with the regulation. And Milord, we are all governed by these. Then Milord, Tet was not at all a qualification necessary for the purpose of recruitment teacher, but we had Milord different training, not Tet. Then Milord kindly turn to, provided that a teacher of class 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special, Milord, this is not relevant.
2001 regulation.
Tara চুপ করবে। Then my Lord will kindly take the trouble to turn to page 163.
Good to hear Bengali in court again.
I'm grateful.
That is the inherent resource. Kindly turn to Milord page 163. That will also Milord clarify the position.
This is what?
29th of July.
29 July 2011.
Yes.
Yes, 29 July 2011.
Yes.
Which clause?
Milord,
Para 5.
kindly turn to Milord clause 5. Rather para 5.
July 2011. Yes, para 5.
For para 5 of the principal notification, the following shall be substituted, namely, teacher appointed after the date of this notification, in certain cases, where an appropriate government or local authority or school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with the NCT Determination Regulation 2001. Therefore, it's very clear that the NCT will have had the basic conception in the mind that prior to 2001, the TET qualification was not available, it's not necessary. Then let B. The minimum qualification norms referred to in this notification apply to teachers of language, so and so for different languages. Now, basic thing without that even in 2011, the NCT found that 2001 regulation appointments did not come within the scope of TET. That is one important thing.
2001
And-
regulation.
If your lordship kindly comes, 2001 regulation, lordship will be pleased to find,
Page number 142.
137.
let turn to page 137.
What is that?
2001 regulation.
What is that?
That is the Lord, the
3rd September.
Last chapter.
সবাই মিলে কথা বললে কোর্ট হবে কি করে?
3rd September 2001.
This is the Millard. The qualification regulations may be called National Council for Teachers Education Determination of Minimum Qualifications for Recruitment of Teachers in School
So
Regulations.
you are referring to which particular regulation?
Millard, kindly see that your lordship will not find date mentioned.
No. Of course, 2001, it was introduced only after the RTE Act.
Right so.
So
But
2001, TET was unknown.
What I
It
say,
was unknown.
that's why Millard, these notifications will give exemption to the teachers who were appointed Millard prior to the knowledge of TET.
Very well.
And this exemption Millard was considered by your lordship. Kindly turn to Millard Mylar's own judgment,
Yes,
para 168.
that has been placed just now by Mr.
Just, may I just repeat? Kindly, page, para 168 is very important.
Page 90.
Page 90. Well, I will read it a little slowly for my benefit. Well, I would rather read 167 to my lord's reasoning to arrive at 168. Importantly, the first and second proviso to section 23(2) of the RT Act carve out a transitional obligation for in-service teachers who did not possess the minimum qualifications at the time of commencement of the Act. They were required to acquire such qualification, including passing TET within a prescribed time frame. The second proviso introduced by the RT Act extended this compliance period by a period of 4 years from the date so and so. The express legislative intent was to bring in all service teachers within the ambit of uniform quality of standards. Then, NCT's notification also reinforces this requirement by stating that the teachers working in unaided private schools, or those already in position on 31st of March 2015, must qualify the TET with the stipulated period. The language of both RT and the notification leaves no room for ambiguity that even those teachers appointed prior to RT, if not qualified, well, this is important, if not qualified, must meet the TET requirement within the grace period. Only those appointed prior to 3rd September 2001 in accordance with the applicable recruitment rules or those covered by specific exceptions were exempted. But this is the finding of the Honorable Court, which really supports my cause. But this is my misfortune, but in the direction portion,
This is just noticing the relevant statutory provisions and ultimately 23 subsection 2 second proviso, pins you down.
the second proviso pins me down, I have no quarrel, but that will not empower the.
Because whatever exemption is given under a notification cannot override the statutory provision.
My lord,
NCT cannot grant an exemption which the legislature is not providing. The will of the people has to be respected, Mr. Bhattacharya.
the deepest of respect, Lord, I just,
Right? And you are expressing the will of the people
I am.
presently.
Now, I am trying to point out, Lord, that the statute says it depends upon the academic authority. It depends on the academic authority.
We will
The
consider.
academic authority felt it. Academic authority felt it that these people, Lord, need not go to TET.
Very well.
But I can also will not concede to the extent that if the court feels that they should upgrade their skill, let them do it. But that should not be coterminous with their recruitment. That would be too atrocious.
Very well. Thank you.
Milord,
Lordship,
I have,
Mr.
give the
Gupta,
same
I have
two
benefit
sub-
that is given to the others, that you may not get promotion.
well.
But you,
Milord, I'll just
have to
state the
go
two
with it.
submissions. Milord. First of all,
Who
by
are you appearing for now?
Milord, state of Tamil Nadu,
You are still
same,
written by State
yes,
of Tamil
yes.
Nadu. Very well.
and Milord, I
Because we
appeal,
have been hearing in from the morning
yes.
adjournments because
Change
there
of
will be a
guard.
new problem.
Milord,
New,
your lordship is not going to adjourn this matter, Milord, so we better be here. Now, Milord, I appear in 14 matters, Milord, but the list is there. I don't have to
very
give
well.
it.
For State of Madras.
First state of Tamil Nadu.
State of Tamil Nadu.
2 points, Milord.
Yes.
By directing compulsory retirement, your lordship has interpreted the second proviso in such a way that it introduces an eligibility condition decades after the person went into service. Now, even though this may be for the benefit of the students, it goes against a very fundamental principle of service law, which also must be applied. That's my first submission.
May I take leave?
Second, my lord.
May I take leave?
Second thing is this, my lord, we have given the facts. For 4,49,850 teachers in total in the government in my lord, Tamil Nadu. 3,28,701 not qualified under TET. In 2 years' time that your lordship has given us, my lord, it is administratively impossible to repopulate, my lord, the entirety of the service.
Statute gave you 2 years in 2017.
My lord,
We have given 2 years in 2025.
no, my lord, no, my lord.
If your teachers do not equip themselves, Mr. Gupta, we wouldn't expect the state of Tamil Nadu to
My lord, would your lordship, my lord,
come
kindly,
forward on behalf of the
my lord,
teachers.
no,
By now, there may be several
my
lakhs
lord,
of
just
teachers.
kindly permit me to end my submission. my lord.
Right.
The difficulty is, my lord, if it's administratively impossible to repopulate the service, my lord, then the schools have to be shut down. That's what I'm trying to say, my lord. And my lord, your lordship's held,
What happened in 2017 when this notification came?
it wasn't interpreted to mean what your lordship has now said.
It is
Your
very
lordship has
clear.
interpreted
is
it for the
very
first time.
clear. It is very clear.
It may be, my lord,
It
clear
is
to
very
your
clear,
lordship, my lord.
required no interpretation, but the court is forced upon to
However,
interpret a plain and simple statutory provision.
all I'm saying, my lord, is kindly give us at least 4 years' time. Otherwise, administratively, my lord, it is impossible and the schools will have to shut down. My lord, this is in grounds 4 and 5 of my review, my lord.
4 years' time.
Yes, my lord.
We'll keep in mind.
Lordship.
Yes, Mr. Patel.
I am for the teachers in the state of Jharkhand.
Acha,
We have-
just 1 minute.
Sorry.
What is the cause title of your petition?
Cause title is, my lord, Akhil Jharkhand Prathmik Shiksha Sangh.
Akhil?
Akhil Jharkhand Prathmik Shiksha Sangh. It is
Akhil
301.2.
दो number में है.
Point 2. We are teachers, my lord.
अच्छा, अखिल झारखंड प्राथमिक शिक्षक संघ झारखंड.
Correct,
You have raised 7 points.
correct.
Oversight of NCT notification which exempted pre-2010 appointees from writing.
I am
test.
starting from.
First, court misconstrued RTE Act 17. Intent was never to retrospectively impose TET on teachers appointed prior to 10. Executive clarification dated 3rd August 17 to the effect that teachers appointed prior to 2010 need not acquire this qualification. Rule 9 of RTE amendment rules violated. Our interpretation has violated rules very well.
Yes,
Treating
I am not
pre-2010,
present.
this is what we have culled out from your petition.
Correct.
Treating pre-2010 appointees with post-2010 appointees amounts to hostile discrimination violation of 14. Sixth, appointees fulfill the eligibility conditions when they were appointed under the relevant state rules. This is the common submission. And new promotion rules 2025 of the state has granted exemption. So state law will override a central law.
So, my lord, I am not going to argue all that.
So which
All
one
that-
will you argue? Tell us out of these 7.
My lord, the point I'm essentially placing before your lordships is that your lordship's judgment now, as my learned friend Jaideep just said, your lordships are virtually imposing a new condition of eligibility by a judicial interpretation, which if possibly the executive had done by a service rule, may have been liable to being struck down by your lordships. And realizing this, my lord, one line of the 2010 notification has been probably overlooked or missed. Please see page 42. We are people who were recruited from 91 to...
You are referring to which regulation?
Yes, please see page 4. I'm
No, we are not looking into every petition because there are more than 100 petitions. It's absolutely impossible to have 100 petitions.
31st March 2010 notification prescribing the qualification.
1st March 2010. It's not in this compilation. Do you have a copy?
In your lordship's judgment, I only have a soft copy. In the judgment at page 41, it is reproduced.
Page 41.
41.
Page 40. Just give the paragraph number.
Para 62.
Para 60.
The reference comes from para 61. This is under that heading where acts and notifications where your lordship have done. Now, please see para 61. Your lordships have said central government notification dated 31st March 10 appointed NCTE as the academic authority. Then thereafter, the 23rd August 2010 laid down minimum qualification. This is what I am reading. Please have the next page, para 4. Teachers appointed before the date of this notification. The following categories of teachers appointed for classes 1 to 7 prior to the date of this notification, we are that class, need not acquire the minimum qualification specified in para 1 above, and C, a teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules.
Right.
Now, my lord, this recognizes a very established principle of service jurisprudence, which says that your conditions for eligibility for appointment, your lordships have subsequently said, promotion will be included in appointment. I have no quarrel with that. Perhaps I may not be able to get promoted till I acquire the TET qualification. But the question is, would my original appointment be also under jeopardy on account of a qualification which is laid almost a decade after or 2 decades after I have come in? And according to me, my lord, the central government has saved us under para 4 subclause C. And once...
Some notification which is prior to the statutory amendment. Statutory amendment has not been challenged.
Well, no,
That is of 2017.
That is the
para
fresh
69
notification.
Look at para 69 of the judgment.
Correct.
The executive has written a letter.
Correct.
Just turn to para 69
Yes.
of the order. Please read it.
I'm reading it.
Yes.
On 3rd August 2017, the Additional Secretary, Ministry of Human Resource Development, Department of School Education and Literacy issued a letter to the state secretaries reminding them that the last date to acquire minimum qualification is 1st April 2019, and no teacher who did not possess the qualifications under the RTE Act would be permitted to continue.
Then-
So, my lord, this would have to be read.
My brother has been more than benevolent.
This
But I-
has been informed as far back as on 17.
I do understand.
Therefore, the executive stand was also this before us,
The-
that this qualification is mandatory. It had to be acquired within 2 years of 2017. My brother has said it's not required for people.
I do
retiring
realize, my lord, I was...
within 5 years. Then even till 5 years, you put it in the next 2 years.
My submission is...
Extension of time.
My submission is that if we are exempted under the basic notification, all subsequent
this is
statutory
now
regime
replaced-
will not come.
But that notification has to yield to the law.
You're not looking at this statutory amendment of the act.
Statutory amendment.
My lord, then
You're
that will
reading some
relate back to
notification.
this act itself. It will not cover a
Statutory
person.
amendment, if it had not had those words, 3rd March or 31st March 2015, we could have interpreted it otherwise. We have put these review petitions only to get assistance from you. How do we interpret
My lord,
the second proviso in a manner different from the
my
one
reading is...
in which we have
My
interpreted?
reading is that if a person is already excluded from this whole new statutory framework, then any subsequent amendment or proviso will not bring him in, my lord. That's
Very-
all that I'm trying.
That's next in seniority,
I go in.
Mr. Giri.
Yes,
Very grateful, my lord.
301.8.
What is the name of your client?
Meghraj Singh and others.
Devrat Singh. Madam, dekho to.
My lord, the cost title starts from page 111.
Just one. Devrat Meghraj Singh.
Yes, my lord.
Meghraj Singh.
My lord, altogether 232 petitioners.
Deprivation of livelihood, retrospective application is irrational. Education is a state subject. State laws predate RT. Education is a concurrent subject, the state subject. Of notification dated 23rd August 2010 exempted teachers appointed prior to the notification. Proviso to 23(2) provides for acquiring minimum qualifications within 4 years for teachers appointed prior to coming into force. That was not a minimum qualification. These are the grounds that
These are the grounds. My lord, they have been argued in one way or the other.
it has
Right.
been argued.
And therefore, my lord, why should I
Yes.
take up your lordship's time on that?
Right.
But please come to the section.
Yes.
This
please.
is what, this is where your lordship seeks some,
Please, we want
Some
assistance on 23
yes.
to second proviso.
My lord, this is something, my lord, which I am advancing before your lordships. Because this is a manner in which if it is read in this manner, probably many of us come out of the net as such. Please come to section 23 once more.
Yes, we are on 23.
My lord, this was there right from the beginning. That is from 1/4/2010 onwards. Any person possessing such minimum qualifications as laid down by an academic authority. Academic authority, my lord, is also subsequently defined
As NCT.
as NCT. Authorized by the central government by notification shall be eligible for appointment of a teacher as a teacher. My lord, subsection 2 may not strictly apply, but for the sake of completion, let me just read it. Where a state does not have the adequate institutions offering courses or training in education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years, as may be specified in the notification. My lord, the second proviso was not there. Probably addition of this or bringing in a qualification, my lord, post prescription of the qualification as per a notification dated 23/10/2010 might have been ultra wise. But your lordships are right. There is a substantive plenary amendment. Provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. Suppose we stop with that. Then also, my lord, all those persons, these 232 persons, like several others, they were all appointed prior to 23/10/2010. They were appointed prior to 1/4/2010. There were many of them are appointed in 2001 and up to 2009. Therefore, my lord, the first proviso also does not hit them in that way.
No, it hit them. They did not realize it. Because they were teachers. It says provided that a teacher,
Yes.
not a person. Person is referred to in 23(1).
Yes.
First proviso does not refer to person.
Yes.
It says provided that a teacher
Yes, my lord.
who at the commencement of this act, that means 1st of April 2010,
Yes.
your client is a teacher
Yes.
and does not possess the minimum qualification under 23(1)
Yes.
shall acquire such qualification within a period of 5 years.
That's right.
So you are a teacher in position on 1st April 10. You are given 5 years time to qualify.
My lord, the minimum qualifications laid down in the subsection 1 is by means of a notification.
Right. So
Insofar as the first proviso
that comes on 23rd August 2010,
that's right.
right? So 5 years cannot be counted from 1st of April. 5 years will obviously have to be counted from the date of the notification.
Correct, my lord. No,
So you are a teacher.
no, my submission is this, my lord. My lord, first proviso therefore says, possesses minimum, sorry. First proviso therefore says, who at the commencement of this act does not possess minimum, as laid down under subsection 1. Now, who lays down under subsection 1? As per a notification. The notification under subsection 1, which has actually continued to remain from 2010 till date, is a notification dated 23/8/2010. My lord, what your lordships have seen, the,
these were people who were exempted.
That also covers.
yes, no, my lord. My lord, the 23/8/2010 notification will have to be read into subsection 1. Because subsection 1 contemplates that there has to be a prescription in terms of a notification. If you read the notification dated 23/8/2010 into subsection 1, section 23(1), then proviso, first proviso would also draw sustenance from that.
First proviso may draw sustenance, but the problem is the first proviso uses the expression commencement of this act.
Yes,
Commencement of this act is 1st April 2010,
yes,
not 1st August 2010.
no,
So therefore, the qualification which is prescribed on 1st April will have to be met by the first proviso. The second proviso is talking about the cutoff date as 31st March 2015.
can I come
By
to,
that time, this
I'll come to the,
NET qualification has come in.
I'll
Tet
come to the,
qualification has come in.
I'll come to the second proviso in a moment, my lord, because I made this submission and my lords felt, I am also hit by subsection, the first proviso.
Both 1, 2.
That's right. Therefore, insofar as 1 is concerned, please read the 23/8/2010 notification into subsection 1 and please have a look at the notification. It's not a question of exemption. Prescription comes under the 23/8/2010.
The second proviso is a complete knockout punch.
No, Lord, I'll come to
No, you don't forget the background. You're on the background.
Lord, I'll come out. I'll come to the second proviso in a
Come to
moment.
the second proviso, right?
I'm anyway tottering on the ropes. Therefore, my lord, let me come to the second proviso in a
There
moment.
are other council.
I'll just take a minute.
Yeah,
I'll just take a minute.
You, but just
I understand, my lord. I'll just take a minute. The notification dated 23/8/2000, this is my submission.
yes.
Notification dated 23/8/2010 will have to be read into subsection 1. It has to be read into the proviso also. When your lordships read the notification, your lordships will have to, because the prescription contained for minimum qualification in the 23/8/2010, this is where TTE comes in, comes about under the 23/8/2010. There is no plenary statute prescription for TTE, nowhere. And then when your lordships come to clause 4, training to be undergone, clause 3, then clause 4, this is also a prescription, not an exemption. The following categories of teachers appointed for classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified in para 1 above. And then, my lord, the prescription comes about. Lord, is it to be construed as an exemption? Because where does 23(1) says exemption? 23(1) says prescription. And prescription would include whatever is mentioned in clause 4. If the prescription contained in clause 4 is...
Was NCT conferred any power to grant exemption?
Lord, if it is not...
How could NCT grant exemption? Being a delegated authority?
No, my lord, if
it could not have granted. It could not have granted.
And therefore, my lord,
the parliament in its wisdom thought that it is better to make it absolutely clear. Second proviso is inserted with effect from 2017, requiring every teacher in position on 31st March to possess this qualification.
Please come to the second proviso then.
Please read it.
Yes. Provided further that every teacher appointed, my lord, would it mean appointed in terms of the provisions of the Act? Because the Act does not have any retroactive operation. It cannot go beyond 1/4/2010.
Or in position as
on the 31st.
Position means not appointed under this act.
No.
Maybe prior to
Maybe
the act.
prior to
No,
that.
my lord, as in or on,
Please,
my lord,
Mr. Giri, we are pointing out. Look at it from the perspective of a child. He needs a good teacher. He needs good quality education. if the teachers are lacking in education, how will they be able to teach the next generation?
my lord, I.
We have looked at it from this perspective. That's what my
Lordships are-
brother,
and
we
our
must tell you where
Lordships
we
are
are.
bound to,
No,
lordships are bound to look at the holistic picture. We may not be, but I understand, my lord, therefore, what your lordships are having in mind. But appointed means appointed in terms of the act. But can the words which come after that, in position on the 31st of March 2015, would it take in persons who were appointed prior to 1/4/2010?
We'll consider.
Who does not possess, yes, my lord, just one moment, my lord. Who does not possess minimum qualifications as laid down under subsection 1. And therefore, my lord, please read the notification again as part of subsection 1. If your lordships are pleased to read it that way, then the qualification that we possessed, which is treated as qualification in terms of the clause 4 of the notification dated 23/8/2010, will have to be treated as sufficient for the purpose of proviso 1 and proviso 2.
Very good. Thank you.
My lord, this is what we wanted to say.
Yes,
My lord,
Mr. Jha. We believe you are next in seniority.
Lord, there is,
Mr. Khurshid, you came just now. They have been waiting for some time.
yes. Lord, can I?
I'm
30 seconds, my lord.
Oh, he has been sitting right from the beginning. Sorry, very sorry. We didn't see you. Very well. Otherwise,
I didn't know, Lord, otherwise I would have given way, my lord. I would have
address us first. Nobody told us.
given, I didn't know.
I was asking, I've asked my friend to go first, just as a courtesy.
Lord, can I just take one more minute, my lord?
You
This
just
note-
now said 30 seconds. And now you make it double.
17/10/2017, there is a notification under 23, under section 18.
17/10/2017.
17/10/2017. It's part of my additional documents.
Very well. What does that
It
say?
amends, my lord, the rules of 2017. There is an explanatory memorandum to this. My lord, lordships could always look into the memorandum for the purpose of sustenance,
Very
though it doesn't govern it.
Very well.
Last line, my lord, in the memorandum says, in providing retrospective effect, interests of no person shall be adversely affected.
Very well.
Please bear that in mind also, my lord, is my responsibility.
See, it was interest adversely affected. You have to take a qualification, take it. Prospectively, you can always.
No, my lord, indeed. My lord,
Mr. Jha, we'll call upon you after Mr. Khurshid.
My lord, my lord. I wait,
I'm grateful.
wait my turn, man.
Well, it's grateful. Well, it's
You appear for whom?
two very short points, Mullahs. I mean, item.
No, not the item. You have to
All
make
right.
the
First
party.
for Meghalaya Sarv Shiksha Abhiyan School.
Meghalaya. मैडम इसमें से मेघालय ढूंढिए ना मैडम कौर नहीं इसमें अलग ऊपर नीचे हो गया है मेघालय व्हाट इज
It's called Meghalaya Sarv Shiksha Abhiyan School.
सर्व शिक्षा
Sarv Shiksha Abhiyan Schools Association.
देखिए तो स्टेट यस स्टेट मेघालय
Mr. Advocate General is here, Mullahs.
सर्व शिक्षा अभियान स्कूल्स एसोसिएशन So, sir, your points raised in the review petition are these.
Please, Mullahs.
There was no TET when the petitioners were appointed in the state of Meghalaya. MHRD's notification dated 3rd August 2017 recognized that the existing in-service elementary teachers who lack the minimum professional qualification should be provided a transitional opportunity for upgradation rather than being summarily removed. Third, the judgment under review conflates both eligibility qualification with quality evaluation. These are the 3
Well,
points.
those are the 3 points. I'm just very briefly going to touch upon 2 issues. One is your lordship's judgment itself, paragraph 169.
Para 169.
Your lordship will just allow me to read paragraph 169. It begins at 168 and then 169. Last 3 lines of 168.
This one. And
Yes.
Well, it begins with only those appointed prior to 3rd September 2001 in accordance with applicable recruitment rules or those covered by specific exemptions such as special BTC or DEd courses, etc., were exempted. So there was an exemption. Your lordships have recognized that exemption. People appointed prior to 3rd September 2001. Thereafter, my lords, your lordships then say, thus read holistically, Section 23 of the RTE Act and the NCTE notifications together establish that TET as a compulsory qualifying criteria for all teachers appointed on or after 23rd of August 2010, and as a time-bound compliance obligation for those appointed earlier without the requisite qualifications. My only submission is requisite qualifications does not include TET, but if your lordships have written this judgment, your lordship knows better what exactly it means. But that's my submission, my lords, the way I read it, is that it does not mean TET, it means any other qualifications that don't have, they've been given compliance period.
Very good. Thank you.
Then, my lords, just through 3 more lines. The sole object is to ensure uniform teaching standards across institutions, etc. We bow to that. My lords, your lordships have made this point about how does a notification bypass a statute. My lords, but there are 2 statutes involved here. One that I believe has not been taken.
NCTE Act.
My lords, the RTE Act. My lords,
RTE Act and the NCTE Act.
12A. And
12A is NCTE Act. 12 capital A is of NCTE.
12A capital is NCT Act. Mullahs, I just want to read out the proviso there. If your lordships will see 12A. Mullahs, the proviso only says, provided that nothing in this section shall adversely affect the continuation of any person recruited in a pre-primary, primary, upper primary, secondary or intermediate schools or colleges under any rule, regulation, or order made by the central government, a state government, Educational Amendment Act 2011, etc., solely on the ground of non-fulfillment of such qualifications as may be specified by the council. So 12A,
Next proviso.
well, I'll read the next. Provided further that minimum qualifications of a teacher referred to in the first proviso shall be acquired within a period specified in this act or under right to children to free and compulsory education act. Well, if your lordship read that with my interpretation of paragraph 169, it is qualifications that have to be complied with in that period, but RTE is not part of those qualifications. That's my submission, my lord. I'm
Thank you very much.
grateful, my lords.
Yes, Mr. Jha, who do you appear for?
My lord, I appear for the tribal
I have one
association
No, just
of
just
teachers.
1 minute.
Well, I'm grateful, your lordship permitting me to appear through the
Yes,
VC.
yes, please. You are appearing for which state
The
or?
I'm in item number 301.68 for the Tribal Welfare Teacher Association of Madhya Pradesh.
Tribal Welfare Teacher.
Teachers Association of Madhya Pradesh.
एक बार देखिए ना इसमें कहाँ है? Tribal Welfare
Teachers Association.
मध्य प्रदेश के आसपास ही होगा.
Yes, ma'am.
अच्छा, point, sir.
My lord, your lordships, I wanted to assist your lordships in interpreting the proviso.
Yes.
Both of them. And since your lordships have positive time, just read it, my lord. Provided that the teacher who at the commencement of this act does not possess the minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And the second proviso says that as on 31st March 15, who are there, if they don't possess it, they will acquire it within 4 years. Now, the section statutory provision says qualifications as laid down under subsection 1. Now, the qualifications that have been laid down under subsection 1 are under the notification of 23rd of August 2010, which your lordships have reproduced, considered on several occasions. But there are certain aspects of it which I want your lordships to just see along with me. Here, my lords, if your lordships will see this notification, there are 4 categories of teachers here, not a single category.
Yes.
The first paragraph, my lord, deals with the qualifications that are prescribed for fresh recruitments after the coming into force of the act. And if your lordships will see under the first paragraph, and TET, which your lordships are concerned, and TET, along with certain qualifications that are mentioned, senior secondary with certain 50%, etc. And in both cases, A and B, it's and TET.
Yes, pass in the teacher eligibility.
Yes, parents. Then if your lordships will turn to paragraph 3 of this notification.
Paragraph
It says-
3.
Paragraph 3.
Yes.
Training
To be under.
Yes, madam.
Training to be undergone.
Yes, madam. It says with BA, BSc. Now, this is something apart from what has been mentioned in paragraph 1. BA, BSc with 50%, B.Ed qualification also eligible for appointment to class 1 to 5 up to January 2012, provided he undergoes NCT recognized 6 months special program elementary education. So even those who don't possess the qualification prescribed in 1 but are BA, BSc with 50%, if they undertake 6 months training, they are qualified. Same is with D.Ed, that is in B. Then 4 comes another set of teachers. They say the following category of teachers appointed in class 1 to 8 prior to the date of notification need not acquire qualifications specified in 1. And here 3 instances are given. Teachers who are appointed.
But sir, your contention overlooks the minimum qualifications which are prescribed under paragraph number 1. Paragraph number 1 deal with minimum qualifications.
My lord.
Minimum. These may be additional qualifications that are required. Diploma, degree course in teacher education. But the minimum is you must have for classes 1 to 5, secondary or senior secondary or senior secondary. Either of these 3 plus TET.
Plus
this
TET.
is for classes 1 to 5. For 6 to 8, you require BA, BSc or again BA, BSc or BA, BSc, senior secondary or BA, BSc. These alternatives are there, but passing TET is the mandatory qualification.
My lords, my respectful submission before your lordship.
You cannot say that if somebody has the qualification in 2, he may not have the qualification in 1.
The reason is, my lord, that the competent authority, that is NCT itself, saying that if these people possess this training, B.Ed, which it has prescribed previously, if they undergo 6 months special training, that is a BTC training which is prescribed there, they will be deemed to possess the qualification prescribed under subsection 123(1). And for these teachers, these 4 categories mentioned in paragraph 1, 3, 4, and there's a 5th category which says that those teachers whose recruitment started prior to the coming into force of the Act and were recruited under the regulations of 2001, they also will not be required to have the qualifications mentioned in para 1. So my respectful submission before your lordships is that the proviso says qualifications laid down in subsection 1. And the qualifications that have been laid down in subsection 1 for us who were working for a very long time is covered either under para 4, 5 or para 3.
Very well.
Para 1.
We have noted.
There's another very big difficulty in Madhya Pradesh. In Madhya Pradesh, the recruitment rules that were existing at the time when we were appointed did not require 50% in higher secondary for appointment. It was simply higher secondary pass. Now at this stage, if your lordships relegate us to TET, we will not even be eligible to participate in TET because we don't have 90% of the teachers of this association who are working in tribal areas don't even have 50% at that time because they were appointed 20 years ago.
Our order only says that you need to qualify in the TET. At this age, you will not be required to go back to the high secondary level and cross 50%. That is not the purport of our order. Our purport of our order is, if you are a teacher in position, if you have not acquired TET by now, you do it by 1st of September 2027.
No,
we are not required to go into this 50% higher secondary pass qualification at this stage.
But these authorities, my lord, here in Madhya Pradesh, when they are drawing up the list of people who to go through this, they are looking at this 50% qualification and saying you are not qualified.
If they look at it and if you are, if it is applied against you, you may seek your remedies before the appropriate forum. Thank you very much, Mr. Jha. Thank you very much.
There was,
Lord, one
there's,
submission.
my lord,
One
and
for
yet
the
another,
state of Meghalaya.
there's
Only
yet
one
another
submission,
issue here.
alternative submission.
Just 1 minute. Yes,
My
yes.
lord, there's
Yes,
one
yes.
issue, one extraction. I beg your lordship's indulgence.
Yes, yes.
My lords, in the state of Madhya Pradesh, there are certain scheduled tribes and they are Baigas and others. And when teachers were appointed there, the state government has enacted an act, statutory provisions for tribal welfare. Under that act, these teachers were given exemption from acquiring necessary qualifications for appointment. Now, I have given list of teachers who were appointed as teachers and are working there in these tribal areas. They are tribals for the last 25 years who do not have this qualification, and they are going to go out simply because now your lordship say that TET has become, though TET is not there in the statutory provision of the act itself, it's prescribed by the notification. So, my lords, my submission is that these people would go out straight away. And this tribal area where no teacher is willing to go, where schools are not even available, infrastructure is also not there. And these teachers have been for the last 25 years at least
Sir,
producing.
if there are qualified teachers who cannot be appointed because of dearth of vacancies, definitely they will be going.
Nobody is,
Notwithstanding that the
nobody is
vacancies in
willing
a
to
tribal
go in,
area.
nobody is willing to go and work in tribal areas.
No,
And
no.
that's why, my lords, the non-formal education and other programs.
If this submission is accepted, then after 2010, anyway, no teacher can be appointed for a tribal area.
My lords, this is the factual situation in
This is
Madhya
all
Pradesh.
an emotional argument contrary to law. This cannot be accepted. Then after
My
2010, no recruitment is taking place for tribal areas. Is your
I just
submission?
point out. If your lordship will give me a minute, I have filed documents
That far. It doesn't sound tenable at all.
No, my lords, it's not my submission.
No, no.
It's the government's
State
own
will
stand. I
pass that
filed
government.
documents to indicate.
Very well.
The
Thank
government-
you, thank you very much.
We have understood.
Thank you very much.
Thank
Yes,
Lord,
Meghalaya.
one alternative submission, my lord.
Yes.
We have total 38,256 in service candidate.
How much?
38,526.
38,500,
38,256, my lord.
256.
Out of which we have
You're representing the
state of Meghalaya.
State of Meghalaya.
Yes, my lord.
Well,
And out of which we have 5,912 MTAT qualified teachers, my lord.
5,912
5,912
TT qualified.
TET qualified teachers.
Right.
We are holding the examination, my lord, on a regular basis. We would be requesting that some sufficient time may be given so that we can comply with the order. I have,
So our order is, the
Only
time
for
is
1st September.
31st August 2027.
yes, my lord, 2 years, my lord. We have
2 years.
the
In
issue
2
is
years'
that
time, you conduct two
we
examinations.
have been conducting the examination, but we have got Garos and Khasis region, my lord. Yes, we are holding the examination.
Four exams.
But
Four exams you get.
the issue is, my lord, that Garos and Khasis are tribes and we have got the local languages. To filling up those vacancies, my lord, in 2 years may be difficult. We are asking for some more time so that we can comply, my lord.
Well,
I understand
we'll
the,
consider.
the
2017 till now, 20.
yes, I understand, my lord, that judgment came on 1st September 2000.
But this was the statutory provision.
Yes, my lord, that I have
We are
seen
only
and I have,
implementing the statutory provision.
yes, my lord. The only difficulty is that if the
Well,
this is
we'll
implemented, we
That's
have
between Mr. Rahim and Madam Mona, who is senior.
But I'll,
Yes.
I'll
only look old, ma'am.
Huh?
I only look old.
You look old.
wait, please.
looks younger.
Thank you. Lord,
You are for whom, madam?
Lord, I am appearing for all postgraduate teachers welfare association item number, my lords.
All postgraduate teachers welfare association.
Association, item number 30154. 301.54. Teachers of West Bengal, my lords.
West Bengal?
Yes, my lord.
1 minute.
Postgraduate on honors, my lord. These teachers are all, actually they were recruited for up to higher secondary. Lord, in West Bengal, your lordship may probably know that there is a category called normal teachers and there are separate teachers for primary, upper primary. This
What, normal teachers?
normal teachers has meant
I have not heard about normal.
there are notifications by the government also.
What normal teachers, Mr. Rahim? Have you ever heard?
There are notifications,
Normal
normal
teachers, no.
sections.
What is the other category?
Normal sections are,
What
they
is the
are,
other
they are
category?
called primary and higher secondary. These normal,
No. We have not heard about normal.
very well not, these are categories. We were all educated for post-graduation also, for teaching post-graduation also. Our problem is, one problem is a peculiar thing that I will come in the end note. Here, when I am reading section 23, your lordship's first question was, will you please satisfy what is the second proviso up to? I will try, my lord, to satisfy that this will not be applicable.
Please, please.
Lord, I will read the section again. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So any person who fulfills will be appointed as a teacher. Whereas state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications as laid down in one are not available in sufficient numbers, the central government may, if it deems necessary, by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. In this, my lord, stopping here for a moment, there are 3 stages at which, my lord, they can extend. One, my lord, when the notification newly coming and the act is new, my lord, then there is no provision by the state giving you more institutions. There are no colleges offering this education. There are no courses or training for this teacher education. Therefore, my lord, this 5-year period from the date of the enactment came in. Now, when within the 5 years also, my lord, provided that a teacher who at the commencement of this act does not possess minimum qualification laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. This is what was read in that notification, a subsequent letter which government clarified that this is not applicable to the in-service candidates, which was read out before your lordships. Your lordship's query is provided further that every teacher appointed or in possession as on 31st March 15 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement. Lord, this has been given only with a view to this 15 is a 5-year period which they fixed from 10 to 15. The act came in 2010. It gave, the first proviso gave 5 years time to fulfill the qualification. So therefore, my lord, within the 5 years, since there were not many institutions offering this course or not unable to complete the qualification which is prescribed by this enactment, your lordships are seeing even today, states are coming up and saying we are unable to make up this institution, making them get educated for TET. So the likewise, my lord, it's a new enactment, and since even the new teachers who are recruited and in place in 2015 unable to acquire TUT, therefore, my lord, this proviso 2 was introduced in my humble submission. It is not that a proviso which was actually a benefit which has been granted to in-service candidates could have been again revived by the second proviso. It could not have been revived, my lord. Number 1. And then, my lord, I am only reading the one again, is that a person possessing such minimum qualification as laid down will be eligible for appointment is there. It doesn't say shall be eligible to continue as a teacher. If at all the enactment wanted me to go out when I don't have the TET or the qualification which is prescribed in this section, the section 1 should read like this: shall be eligible for appointment or to continue as a teacher. Since there is no such, my lord, prescription in this enactment, this honorable court, my lord, in my humble submission, could not, my lord, presume a retrospective application of this act. Your lordships are aware, my lord, I can't carry coal to Newcastle. Devin Katti principle, which is till date not pursued, followed by this honorable court, is that when an advertisement is issued, when somebody is recruited, you have to only go by the rules then in existence. You can't subsequently, after a person joins a service, you cannot now retrospectively apply a rule which is now introduced. And then, my lord, for the basic service law principle, my lord, this will be, if this interpretation, if it is given, that even to continue as a teacher, this provision will be applicable, will be contrary to the basic principles, in my humble submission. Your lordship will also...
Thank you, madam.
Lord, just one more, my lord.
Thank
Lord, the normal section is what the West Bengal says, is that, my lord, our appointment itself is for the High Court judgment also in several cases mentioned that is a normal section will include from 5 to 10, my lord, class 5 to 10. The peculiar problem for West Bengal teachers today is that, my lord, we were teaching up to 10th. In fact, we can teach higher secondary also. But due to this bifurcation, my lord, now they are made to teach only upper primary, asking me to now get a TET qualification, which is peculiar to West Bengal, my lord. I am a postgraduate with the training to coach, my lord, even the higher secondary. So therefore, we have a problem.
Thank you, madam. Yes,
Very
Mr.
well.
Rain. Who else is there senior to you?
Who is of course also retired.
I'm simply
Acha, Mr. Gangle is there.
301.62.
Acha.
My lord,
You are appearing for?
301.62 intervention applications on behalf of the teachers. Lot of arguments have been argued, my lord. Only this, your lordship has also said, pointed out in the para
Acha, this is this serial number?
301.62 intervention application
Intervention application in 301.62.
on behalf of
Yes,
teachers,
yes, please.
700 teachers. my
Yes,
lord.
please.
Prior to 2001, they were appointed. And in para 62, your lordship has already quoted and that has been argued. 4, and there is an exemption of TET. My submission is this, that we are exempted in accordance with that. TET is not required. Second point is this, that Article 309(11)(2), it is a status and it cannot be taken away. The main argument is, as I was hearing, that looking to the teachers' efficiency, this examination is necessary. It is a dangerous trend. It can be in every service. That is the main point.
21A has been brought in with a purpose, sir.
So, my lord, then to every service.
Very well. Yes, Mr. D.S. Naidu now.
May it please, Millets. Millets, I represent the teachers from the state of West Bengal. And they were all. Please.
Mr. Rahim, Mr. Bhattacharya, Madam Mona, you also.
Yes.
Only 1 minute. Lord, it just shows me, Lord, that the
Huh?
teachers over there. It just shows me, Lord, that the apathy of the teachers over there, how they're affected.
Because, my lord, the state of West Bengal and board has not come up.
Nice.
Millets,
Well, just 1 minute. Let
Millets.
Mr. Naidu come. Today we will not.
if I'm permitted 30 seconds, Millets,
Yes, yes.
if I'm permitted.
1 minute.
No, Millets.
1 minute. No. Because we are hearing the same argument again and again.
Yes.
We have been indulgent, but that does not mean, Mr. Naidu.
Absolutely, Millets.
Right,
I can
that
never
same
overcome your
argument
lordship's
will be,
kindness. Could my lords
presented
have
before us in a different language.
compilation?
Just 1 minute. This is a review. We have heard from 2 o'clock, right?
We are all great.
The review, the error has to be such that it does not require more than a minute's argument to demonstrate.
Precisely, Millets. Could my lords have, since I have taken the SCC copy of your lordship judgment?
No, we have the SCC copy.
Yes, Millets. Could my lords come to para 90?
90.
90.
That is the
That
bedrock of the
permeates.
judgment.
That permeates.
Para 90 is the bedrock of the judgment.
Indeed, Millets. That's why I begin with that one. That permeates the spirit of the judgment. And my lords have taken recourse to, in my humble submission, a purposive interpretation coupled with Hayden's principle of curing a mischief. This is one thing. And Millets, the question that I may have to pose myself is this, Millets. Can a qualification which has not been explicit be read into any recruitment process?
2017, this proviso was brought in,
Yes, Millets.
right? Why did you not challenge it?
Obviously, Millets.
Why
my
did the
humble
teachers
submission
not
is-
challenge it?
My humble.
Just tell us this.
Yes.
It has been almost 9 years on the statute book. The parliament wanted to give 4 years' time, but it is brought into effect with retrospective effect from 15, thereby curtailing that 4 by 2 years. And even then,
My
West
answer,
Bengal teachers, they did not rise from their slumber.
my answer is this, Millets.
Now everybody.
We have never.
Now everybody,
Change of-
what now everybody? What is the,
Millets.
if we interpret the law as you are asking us to interpret, this second proviso will be rendered redundant.
May I say with great respect, Millets,
Redundant.
the only difference between first proviso and second proviso, as I understood, was that, Millets, whatever the time frame that was given, there were representations from
So,
various states,
extended.
and it was extended.
Extended,
So
right.
the first proviso, if good enough, the second proviso is only otious, except for certain categories of extension of time.
Second proviso makes it absolutely clear.
It's been made explicit, Millets. It's been
Whatever
made explicit what is
ambiguity was
implied.
there in first proviso,
Yes, Millets.
that ambiguity is removed by the second proviso.
Millets, that's what I say, Millets. It's only clarificatory in nature rather than giving anything extra, barring the time frame that's been extended. My humble submission is this, Millets, that has been repeated, that the section does not, or rather the article and the section, they do not read anything vis-a-vis the qualification or minimum qualification. I was recruited, we were all recruited for that matter, between 2001 and 2010. Then millets 2010 rules superseded. Then 2011 there was an amendment. Eventually 2014 was the culminating factor. Millets, amendment or no amendment, my submission is this, millets. All through I've been qualified when I was recruited. And millets, I've had a vested right in the process of my recruitment and my appointment. And millets, any rule or regulation which has come in effect, if that supersedes something else, millets, the vested right in terms of Section 6 of General Clauses Act cannot be diluted. This is my humble submission.
Very good.
Lord, only,
Yes.
Lord,
Yes.
I will not repeat anything, my Lord. I will not repeat anything. Lord, your Lordship may kindly see, my Lord, your Lordship, my Lord, at the heart of the judgment, my Lord, is the fact that your Lordship mounted, my Lord, uniform teaching qualifications, A, and your Lordship said, my Lord, that TET is a constitutional necessity. For which reason, my Lord, Article 21A, and my Lord, the provisor, my Lord, your Lordships have, my Lord, held it very firmly, my Lord, and rightly so, my Lord. Now, my Lord, today, my Lord, the ground reality is this, my Lord. In Bengal, my Lord, the first Tet was held in 2014. No, the exam
Everything
was,
will change now.
no, I'm not
Hopefully.
saying, I'm saying,
Hopefully.
we all pray for that. We all pray for a better.
Let us hope for the
Yes,
change.
of course, we would.
There is an order.
Yes.
There is an order of this court. 2027 is the deadline.
So, my Lord, if your Lordship, my Lord, say the second was held, why these people did not come, my Lord? The second was held after 7 years, 2021, A part. B is, my Lord, if your Lordship sees, my Lord, your Lordship.
Everyone was looting the state.
Lord, that, my Lord, is that teachers,
So
my Lord,
now let us hope for a better future.
we always have to, my Lord, look to a future, to a dawn, my Lord. We
Lords, I
can't-
can appreciate
only 2-3
this
things.
happened almost 20 years ago. By then it was not in
Only
contemplation.
2-3 things.
Neither the
Lord,
constitutional amendment
Lord,
or the enactment, neither of them was there,
Only
millets.
2-3 things. Lord, the word which was troubling your Lordship was, my Lord, if your Lordship sees, my Lord, your Lordship have seen, 23(1), my Lord, your Lordship said, my Lord, any person, and you were not a teacher at that point of time. But if your Lordship sees, my Lord, the proviso, my Lord, the first proviso. So provided that a teacher, now the word person here, my Lord, should be read to mean a teacher. Provided that a teacher.
Sir, 23(1).
Yes,
At the risk of repetition, we are saying 23(1) says,
yes, my Lord.
any person who wants to be a teacher
Please.
must have the qualifications under 23(1).
Correct.
Any person who wants to be a teacher. And first proviso says a teacher. So that presupposes that you're already in service. So if you're in service, you are given 5 years time to upgrade yourself.
To give the
Millet, there were instances, if I may add, Millet, there were instances when relaxations were made.
Like
Millet,
a broken record, we have been repeating the same
no,
thing
Millet.
again.
There were instances when,
Would your
there were
Lordship then only
instances
indicate
when
something, Lord? I will.
states represented to the central authority,
I will only
that
reiterate,
because we
Lord,
don't
what-
have the wherewithal, it should be exempted. Such
there are two-
categories which have been exempted from minimum qualification, they were given this opportunity, not the ones who had the qualification by word go.
Would it be 4 years, my Lord?
Why we didn't challenge it? There is a letter of 2017. It is the amendment of 2017. Now,
Whose letter?
He says already there 6 months.
MHRD's letter, which reflects
What is the date?
3rd of August 2017. The amendment came on 10th of August 2017. Now, this letter of MHRD,
3rd of August 2017. What did it say?
I'm
Just tell us.
It laid down detailed guidelines to all states and union territories about gaining the qualification required and to meet the deadline. And the only thing it referred to and discussed in detail is getting a DLED, which is a diploma in elementary education. And this, Your Lordship, the reason why this is important, I tell Your Lordships, Regulation 5, Your Lordship will again, I'm sorry to say, read Regulation 5 of NCT 2010 regulations. Regulation 5 very categorically says that those regulations.
Can you please come to para 69 of our order?
Yes, Your Lordship.
Have we read 3rd August 2017 erroneously?
I'll tell Your Lordship's why.
You just tell us that.
Yes, sir.
Just look into 69. Have we read the 3rd August 17 order erroneously?
No, but the question is,
We have said, Madam, just see 69.
what were the
Additional Secretary MHRD issued a letter to the state secretaries reminding that the last date to acquire minimum qualifications is 1st April 19, and no teacher who did not possess minimum qualifications under RT would be permitted to continue in service beyond the given date. Is it a wrong interpretation of the letter?
No,
Lordship did not interpret the letter. Your Lordship merely said minimum qualifications. But what are the minimum qualifications? The question. There are 22 steps which the 2017 letter talks about. Everything involves diploma in elementary education and online distance courses for diploma in elementary education. There is not a whisper about TET in that.
Very well.
And I'll tell you, Lordship, why that understanding is. That understanding is in consonance with Regulation 5 of 23rd of August 2010. The Lordship just read Regulation 5 once again. I know your Lordship has read it. It very categorically says, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with NCT 2001 regulations. Under Section 23, the gold standard is NCTE. 23 does not say what your minimum standards are. 23 says NCT will lay down minimum standards. Rightly or wrongly, NCT 2010 has two categories. Those who are prior to the notification, those who are post-notification. Whether it is in one way or the other, that is the law. NCT 2010 is a law. It is in consonance both with 12 way of NCT Act as well as RT. It is not contrary to either. NCT 2010 notification creates two categories. Those who are appointment prior to the notification date and post notification date. Prior to 2010 notification date, they say the standards and qualification of 2001 will apply. Post 2010 notification, 2010 will apply. So all those who are selected prior to a selection process prior to 2010 are governed by NCT 2001. It does not mean there are no standards.
Very well. Thank you.
And that
Anyone else?
They form a different class when it comes to 2000 up to 2010 minutes.
My lord,
Form a different class.
my lord, I am appearing for Women Teachers Association.
2010 may be a justification.
The TET exams be held after every 6 months, my lord. Otherwise,
I am appearing for UP Women
Mr. Rai.
Association. UP Women Association, my lord, of teachers of UP, my lord. My lord, the only one, first of all, my lord, there should be a schedule in which, my lord, the states have to conduct these exams, my lord, so that all the backlog may be cleared, my lord. That is the first, my lord. And secondly, my lord.
In case they are not holding the exam within time, you are at liberty to approach the court. The problem is,
My lord, it doesn't happen, my lord. My lord, if it is a part of the order, my lord, they will listen to it, my lord. And then, my lord, lady members, my lord.
You find you were here right from the beginning.
Yes, my lord.
What did Tamil Nadu say?
Yes, my lord. They said 4 years, my lord. Then my lordship accepted.
No,
that.
because they say that if the teachers in position they don't qualify, we will be without
schools will be
teachers.
closed, my lord. Yes.
So whose duty it is to hold the TET under the law?
States, my lord, but they
States.
yes, my lord.
Now, state on the one hand will say that don't require TT to be acquired by the teachers. On the other hand, they will say that we will be out of teachers.
Yes,
What is
my lord,
this?
lakhs of vacancies are there, my lord, in the schools, my lord. They are
So
not.
there are lakhs and lakhs of individuals who have qualified TET and are waiting in the wings. Let them be examined. Let them be assessed.
Yes, my lord, I'm only praying, my lord, to give some exemptions to ladies, my lord.
Sorry?
Some exemption to ladies.
Ladies are in our judicial service more than 50%. And you want exemption for ladies?
My lord, now the situation is different.
Just see
my
the judgment authored by Brother Manmohan in Arshnur Kaur.
you have said now their time has come and there will be reservation for men.
My lord is absolutely right, my lord, but reservation is now happening in Supreme Court also, my lord.
My lord, may I, my lord, only take 1 minute, my lord? My lord, only one.
Please allow us to reflect.
My lord, may I handle
What is
just
reserved
one
on the
notification?
executive?
Only 1 point, my lord.
We will have to work it
My
out.
lord, 30
Whatever
seconds,
is
my lord.
best for the-
My lord,
May I handle
30
it just
seconds,
one
my lord.
notification?
Only 1 point, my lord.
My lord, may I hand it over just 2 notifications, nothing more, nothing less.
Very well. Give the notification.
May I hand it over? this?
We'll
My lord,
consider.
one is state
Yes,
conduct guideline and another one is
Public
extension.
Garden Forest matter.
My lord,
My lord,
only one line.
Your Lordship, just to.
One thing, my lords, I wish to
My lord,
find
can you
out.
consider
Your
that
Lordship, I wish to
extension?
point
West
out
Bengal
about Jammu
extension.
and
Nothing more,
Kashmir.
nothing less.
May I make a limited submission
301
only on the
point
retrospective
555.
effect?
We will look into
Your
all the
Lordship.
positions, whatever points are there. Our notes are ready. We will
Your
look
Lordship,
into it.
Your Lordship, may I?
Lordship, very
Lordship,
important
may I
2
just
points
submit
which
one
is
thing?
already concluded the entire matters, Lordship.
Your
On
Lordship-
first is there, give the Lordship the time to the teacher eligibility test for, and second is there, Lordship, very important.
We will
The
consider.
attempt,
Your
Lordship.
Lordship.
Give the attempt to the more
Your
than
Lordship,
one to
may I
more than.
just submit about
What is
Jammu and
that?
Kashmir?
Very important. Physical education and the music teachers is not considered under the act of the TET examination. In this, Lordship,
Sharma ji, bulaiye bhai.
Please, my
Your
lord, only
Lordship.
one sentence, my lord. My lord, they are, my
Your
lord,
Lordship,
the
may I just
teachers are
submit
ready
about-
to
Your appoint is prior to 2009. We are ready to give the TT test. Only we should be given promotional post also. And if we fail, my lord, we will lose the service as well as promotional post. That is only what our contention is there.
I seek permission to withdraw 301.4.
Forest.
I'm for the promoters.
No, first, today we'll hear Mr. Fernandez, Madam, and Mr. Prasad.
Only last time, Lord, your Lordship didn't issue notice in my application.
Wait for a minute. Get all the DC and the
Yeah,
local
they
admin-
are
I know, so
local
that,
admin-
video.
that report has come, Lord, where they say that they have 400 crore.
No,
around
No,
200.
not that 400 crores. Whether they have taken.
Oh, I see
possession of
the
that.
deputy commissioner. Lord, at some stage, your Lordship will have.
Your Lord, yes.
Here the surplus, where will the surplus go? That hearing your Lordship will have.
There is a minutes of meetings that we filed yesterday because we were to, yeah, we have hard copies. We have hard copies. We just hand it over. Your Lordship. Yes, so we've given the modalities, my lord. We are very sorry. Your Lordships directed us 48 hours before. Yes, so therefore, my lords, SBI CAPS is going to be the agency which is going to conduct it.
Yes.
And they have given a detailed timeline, a detailed schedule in terms of various steps to be taken. Your Lordship straight away comes to para 6, para 5 onwards, page 3. Page 3, Milords, para 5, there's a common consensus, Milords. We spoke to income tax, SBI CAPS, the Hyderabad office, the GFIL committee and the amicus. So SBI CAPS, Milords, will be at para 5, the agency tasked to conduct the auction. At para 6, Milords, auction would have 3 phases: pre-auction phase, actual auction, and number 3, post-auction modalities. If your Lordship kindly comes to para 7 at page 4, we have given the various stages, the respective milestones. So on the left-hand side, Milords, phase 1, pre-auction. So in that, there are 3 steps. The first step is receipt of necessary information, because we have clarified that below. What is that necessary information? That shall be the starting point, T0. That will how the limitation starts. And everything will have to be given to SBI CAPS. After they receive at serial number 1, then at serial number 2, SBI CAPS will prepare the model tender documents and the RFRP, request for proposal, the bid documents that they will prepare, which they will take 60 days. So T plus 60. And then number 3, approval of the RFRP and the reserve prices, Milords, that the income tax department and the Golden Forest Committee together will assist your Lordships in that. So this is stage number 1. Stage number 2 is the tender approval from the department. So once
Just 1 minute, Mr. Fernandez.
I'm so sorry.
Why do this exercise?
Report of the committee, this exercise will have to go later. I'll tell you, Lordship, why. The report of the committee says it has got 404 crore with it. Verified claims is only 200 crore. Rest are all unverified claims. Let them. So unverified means where checks have gone and returned, or checks have.
If there's surplus with the company, it will remain with the company.
No. So that's what I'm saying.
So it will go as dividend.
No, but why should it be this piece put to sale if the money already with the company is more than not sufficient to be?
If the company is to be liquidated and it has gone to liquidation.
It's not to be liquidated.
What is
Lord,
to be done?
I'll tell you, Lordship. So this is a matter where
Minutes will have
just
to be
give me
sold
5
and
minutes,
declared.
2 minutes, Lord. This matter is a matter where at all points of time, right from 98 onwards, 2006 on affidavit, Lord, it has been always disclosed that the assets of the company have always been more than the deposits taken from. No case of diversion, no case of money laundering. It's only a question of Lord SEBI saying that you had not registered with us, and because of which Lord SEBI imposed a restriction. 86 to 98, company has been servicing every Lord depositor without any default. Today there is no there is no issue Lord with regard to any default.
That cannot be. This company has been lying before us for how many years?
No, I'm talking prior to 20
20
years. I'm talking of 98, which is 30 years.
Just wait. We'll have to go through this.
No, I'm just giving, because if your Lordships get into this exercise, if there is enough money already with the committee
committee, my lord, has already worked for about 20 years.
Who are you appearing for?
I'm for the original promoter, my lord. I hold 72% of the shares. I've been there. I've been appearing in this. I've been appearing. No, what will happen today, my lord? Today the property value is, my lord, 4,800 crores.
Submission, but I'm contesting.
No, but there has been no. There is a 2006 order. There is a 2006 order. Can I just? So she can't just start in between. I'm still continuing, Lord. There is a 2006 order where your lordships have taken a view that how will the surplus be dealt with has to be decided by this court. That has never been decided by this court.
Decide once there is.
No, but why should there be more money if there is already enough money lying in the committee?
Company is dead today. Who's functioning?
No, company is the company. There is no liquidation order. Please appreciate.
There has to be.
No, there is no liquidation order. Your lordships have transferred everything here.
Yes, it will stand liquidated. Only principal interest.
Even if it is, let me assume, even if it is liquidated, ultimately.
We'll give it to the shareholders.
So I'm holding 72%.
You'll get the money in case
So
you're entitled to it.
They will definitely. I'm only saying,
Every
Lord,
shareholder will get it.
your lordships are not doing a liquidation proceedings. Please appreciate.
20 years the company has not been functional. See, companies
Because of SEBI. 98 SEBI interdicted the company from doing anything further.
Maybe.
And there is a restraint order operating.
Maybe the company is non-functional for last 20 years.
Because of SEBI, my lord, because of SEBI.
Whatever it may be, Mr. Singh, it will have to be struck off the rolls.
It
The
has
company
not,
not functioned
please
for 20
appreciate,
years.
it is
We'll have to
all,
take it to
it is
liquidation.
all under blood interim orders,
No, Mr.
that this is all
Anyway, Mr.
continuing.
Singh, this argument does not appeal to us.
Your lordships are not doing liquidation. Your lordships are only dealing with the claimants. And your lordships have been actually extending. The last date that your lordship extended was July of 2025. Now, July of 2025, all the claims that have come, they say is only going to maximum. Unverified claims also will take it to another 160 crore as against what money they already have. 160 crore is all that is required. So why should the company go in liquidation? The liquidation order has not been passed till date. So sometime your lordship will have to hear us as to whether what will be the status of the original promoters or the shareholders, so to say.
First of all, we'll have to decide the promoters.
No, I'm only saying give some hearing. Give some hearing. No, the liquidation. Just see, there is no liquidation order passed.
Investor forum. It was my application that 2018 this report directed that at least 70% of the principal amount should be disbursed. Was disbursed. Now only 30% is to be disbursed so that at least principal amount
That's only principal.
is disbursed to the investors who are traceable. But 30%, the status report says that only about 200.
No, see, but the problem today is.
And they have 400 crore.
No, see, Mr. Singh, it doesn't work like this. Suppose there are 100 shareholders. You cannot say that 30 are traceable, 30 will get their entire money.
Shareholders, depositors.
Whatever it is, out of 100 depositors.
50,000 investors are traceable.
No, but how many are there? How many is the total?
No, your
You know the
lordship.
total figure?
No. So to decide,
not correct.
one second. Let me explain, Lord. Let me explain.
How many investors do you have?
Let me explain, Lord. This is a
Approximately
matter.
24 lakhs. Approximately 24 lakhs.
This is a matter. This is a matter which has engaged the attention of this court. In 2006, your lordships gave a cutoff date. Anybody has to apply by that cutoff date. Only is to be considered to be an investor. Thereafter, your lordships extended that date to July of 25.
The act does not work in that manner.
No, but your lordships have rejected claims of people who came after the cutoff date. High Court has a rejected claim of people who came after the cutoff date. It can't be only to ensure the committee.
Go to the Investor Protection Fund.
Just see the affidavit of the committee. Just see the affidavit of the committee, my lord.
Please examine it, Mr. Singh.
No, I'm saying just see the affidavit.
Forget the committee and us. See, we are all governed by law.
No, but the committee has. No, there is a date by which people have to come and make a claim.
So, if the claim is not made, the money will go.
It can't go to the central.
It goes, there's an Investor Protection Fund.
But there has